All rise. The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court now sitting.
Thank you, everyone. Please be seated. Well, good morning, everybody, and welcome to the Kansas Supreme Court. I am Justice Eric Rosen, and unique to this week's court proceedings is that Chief Justice Marla Lukert will not be participating this week, and I will be filling in for her during her absence. And she wants everyone to know that she's doing well in her recuperation and thanks everybody for their well wishes. For those of you unfamiliar with this court's processes, I would like to explain that all of the justices are familiar with the facts of the case and the parties' arguments, having read the briefs authorities relied on in those arguments, reviewed the district court record, and otherwise prepared for oral arguments this morning. And we look forward to the parties' oral arguments and our exchange with the attorneys. But before we call the cases, I see that we have a group, and I would ask Mr. Skeens to please come forward and introduce your group. And I understand you're the Blue Valley CAPS program, and maybe give a little explanation about your program. And thank you for being here. We know you're kind of an annual visitor, or maybe twice a year you come. So thank you for being here.
Yes, thank you, Justice. May it please the court, Alan Skeens appearing with my CAPS Law and Public Safety class. CAPS stands for the Center for Advanced Professional Studies, and we're in the Blue Valley School District in Overland Park, Kansas. Students in the class are interested in some type of legal career, so we explore those opportunities during the course of the semester. And yes, twice a year we have a chance to come up and appreciate the opportunity to watch the court in session this morning. And please give Chief Justice our best wishes. Thank you.
We will. Thank you, Mr. Skeens, and welcome, students. And I hope what you find this morning is enlightening and not intimidating to your pursuit in your legal careers. So it's good to have you here. It's good to see your smiling faces. With all that, Mr. Shima, would you please call this morning's docket? Mr. Doug Shima is the clerk of the Kansas Appellate Courts.
Your Honor, may it please the court. First case on the 9 a.m. docket for Wednesday, October 29th, 2025 is appeal number 128226, State of Kansas versus Hunter C. Clift, appeal from Sedgwick County.
Good morning, Your Honors. Assistant District Attorney Lance Gillette on behalf of the state of Kansas appellant in the instant case. I would request 4 minutes for rebuttal, please.
Good morning, Justices, and may it please the court. Kelly Reynolds for appellee Hunter Clift, present and ready for argument.
Thank you, Mr. Reynolds.
Second case is appeal number 125691, State of Kansas versus John C.T. Boese, appeal from Marion County.
Good morning. May it please the court. The appellee petitioner, State of Kansas, appears by Stephen Obermeyer. I'm an Assistant Solicitor General, present and ready for argument. May I reserve 3 minutes, please?
Yes, thank you.
May it please the court, Michael Whalen on behalf of John Boese, present, ready for argument.
Thank you, Mr. Whalen.
Thank you.
Your Honor, that concludes our 9 a.m. docket.
Thank you, Mr. Shima. With that, I'll call the first case on the 9 a.m. docket, State of Kansas versus Hunter Clift, case number 128226. Counsel, you may get assembled at the table, and Mr. Gillette, you can approach when you're ready.
May it please the court. Assistant District Attorney Lance Gillette on behalf of the state of Kansas appellant in the instant case. I would again request 4 minutes for rebuttal.
4 minutes will be noted and
you.
granted. Thank you, Mr. Gillette.
The state will initially just note that we believe that the factual summary that's been provided here is fairly clear. There's not a lot of dispute about the facts in this case at this point.
When you say factual summary, you mean the factual summary of the court or the factual summary of the district court?
Not the factual summary of the district.
I thought that's what you meant. Okay,
Yeah.
go ahead.
The facts that were presented and as are argued in the state's brief, and the only question really here today is whether or not the district court reached the correct conclusion in determining that KSA 2163-32 violated the Second Amendment. As this court is well aware, the Second Amendment provides that a well-regulated militia, being necessary to the security of a free state, right of the people to bear arms, shall not be infringed. Historically, there are a number of ways that the possession and use of firearms can be regulated. In this case, the statute at issue here is KSA 2163-32, which was passed by our legislature and enacted in 2014. The statute criminalizes as a misdemeanor the knowing possession or carrying of a loaded firearm on or about such person or within such person's immediate access and control while in a vehicle, while under the influence of alcohol or drugs, or both, to such a degree as to render such person incapable of safely operating a firearm. There are numerous statutes, or there are numerous exceptions and rules provided in this statute that render the statute inapplicable to certain individuals under certain circumstances. The state would begin its argument here by noting, as we do in our brief, that whatever analysis was being conducted here by the district court, it is unclear. But what is clear is that it was not the proper Second Amendment facial constitutional analysis, as is required by United States Supreme Court precedent and historical precedent from this court as well. Unless the court has questions to that end, I believe that at this point.
What do we do with that when the court suggests he's conducting a facial analysis, but then goes into as applied kind of scenarios, goes into overbreadth kinds of that is unrelated to a typical constitutional facial challenge? What do we do when there's this kind of one-off or even two-off analysis by the district court to reach its conclusion? Do we just ignore it and say you right for the wrong reason, or what's your suggestion here?
The state's suggestion would be to simply reverse and remand. Whatever force this court might feel necessary upon directing such a remand, the state would accept. There is also the possibility of right for the wrong reason, as is argued in the defendant's case here. However, candidly, I don't believe that holds up here. The defendant in their own brief points out at least two instances. There are notes that they appear to concede that the defendant in this case was actually in possession of a firearm. So based on that concession alone, the provision that the district court felt was unconstitutional here didn't apply. They do not dispute the fact that the district court here found at least two factual scenarios in which this statute would be constitutional. The defendant themselves then goes ahead and points out yet another in their example of hunters in western Kansas that place their guns in the bed of a truck, then get drunk and have a designated driver driving them home. Again, in a facial constitutional challenge, that is yet one more example of how the defendant cannot succeed on a right for the wrong reason claim here, because there are numerous examples of how this court can recognize sets of circumstances under which this statute would be valid. So basically, to conduct the correct test here, regardless of what happened, of whether this court just directs this, a remand based on the record here to proceed with, as applied or whatever other challenges may come up down the road. Or whether this court determines that the district court's ruling here, constitutes a finding that this statute is facially constitutional. I think that that could happen as well, because under the test from United States versus Rahimi, the correct test for a facial challenge is quite clear. It's not easy to apply, but it is very clear. This court has, and any district court should consider whether the statute is consistent with the principles that underpin our regulatory tradition. And consider
why
whether,
did you get to that? That was kind of, because that's where I think, well, if we do get to that question, explain to me how the state has established that the statute is consistent with the historical tradition of firearm regulations.
Sure.
And how far, how limited are we in looking at that? So kind of a general, what's your view here?
the state's view, and as noted in our brief, we would point to, there are, I believe I put, the state notes no less than 9 cases in its brief, as well as 2 more recent cases from federal circuit courts of appeal, in which the regulation of the possession of firearm by those who are presently intoxicated can be criminalized. To the state's surprise, even candidly, my personal surprise, one of those statutes is even from the state of Kansas, going all the way back to 1867.
In the history of that, our Kansas statute, and a number of these that you cite to were enacted years after the Second Amendment was drafted. So how, what's your view of how general can we be in going back and looking at what corresponds with our tradition? That makes sense, but it's kind of, and I think as I've read these cases, circuits have kind of struggled with that question, because some of these were adopted at our statehood, 1868, around in that time period, but that's 100 years after the Second Amendment was written. How broad, how general, how far can we go?
So I guess that I would say there are 2 things that I would say. I think we can go back as far as other courts have here, and in part, again, as we know, that does reach all the way back to the 1800s, the early 1800s, much less than 100 years later. And part of the reason that has been articulated for the ability to do that actually ends up being the 14th Amendment, which provided for equal protection. Because until that time, the Second Amendment was not being equally applied to individuals in this country. And therefore, courts have consistently allowed for reviewing courts conducting a facial analysis to go back until that 14th Amendment was ratified, significantly later, around the time that the cases cited by the state were being decided. And so I think that's how this court can consider the time frame here. In specifically, the state does want to direct this court to the Second Circuit's decision in James that collects all of the 7 of these historical statutes going back to the mid 1800s. There were several other cases noted going back to that same time period, including the very early 1800s, 1837, criminalizing those with alcohol addictions. The issue here is even narrower than that. The state would suggest we're not talking about just someone with an alcohol addiction. We're talking about someone that is presently under the influence of alcohol to a degree that they could not safely operate a firearm.
Well, I guess I want to get past the first step of the federal analysis, which We haven't established at this point in your case that the defendant was unlawfully firing his weapon, or was anything other than a law-abiding citizen. I mean, I realize he was drunk, but, or had the high blood alcohol content. But there's nothing else about that. I mean, he's presumptively covered by the Second Amendment, right? You can see that part.
Correct.
Yeah, okay.
However, being presumptively protected by the Second Amendment doesn't mean that it applies to you in every instance or circumstance. And that's what we're facing here, is the fact that he was presently under the influence of alcohol. It's in the record. His blood alcohol content was nearly twice the legal limit for driving a vehicle. And yet we're supposed to just believe that this is an individual that could operate a firearm. He can't operate a vehicle. This is an instance where the state would also know, and if I may, Your Honor, I recognize I'm out of time.
Go ahead, Mr. Gillette.
At no point did the district court or the defendant attempt to carry their burden at the second step to demonstrate that there is no set of circumstances that exist under which the act could be valid. The district court here found sets of circumstances where this act could be valid. The defendant, again, identifies yet another set of circumstances in which this act would be absolutely constitutionally valid. As a result, a facial challenge to the statute must fail. And this case should be remanded for further proceedings, at which point, any additional challenges or remaining challenges regarding Section 4 or as applied challenges can be litigated properly.
Very quickly, how would you articulate with specificity the historical analog that would support a finding that there are circumstances in which this statute could be constitutional?
I would direct this court to the two federal cases. I think those are probably the most easily identified steps here. That would be United States versus Connolly, Fifth Circuit Court, that's cited at page 14 of the state's brief. And then
well, those are recent federal court decisions. I'm looking for the historical analog that you're relying.
Correct. And I'm citing to these cases, that case, and then as well the I believe it was the Second Circuit case. I want to say it's James that's cited in the state's brief, because those cases collect the historical analogs, including the.
Well, are you pointing to any particular historical analog? That's what I wanted to ask you about.
I think there are 11 that are identified throughout those cases and identified in the state's brief that are all analogous.
All of them are analogous? I mean, they have varying levels of specificity.
Sure.
Well, give me your best historical analog from the state's perspective.
The state would initially note, in responding to Your Honor, we don't have to have a one-to-one equivalent. So that would be the first thing that the state wants to make sure that this court recalls. We don't have to have a dead ringer or a historical twin. So we've got to be close. I think the Missouri case, Shelby from 1886, clearly prohibits those that are intoxicated from going abroad with firearms. That's just carrying them in public. I think that's a good example. The 1867 Kansas statute that prohibited any person under the influence of alcoholic drink found simply carrying on their person a pistol is subject to arrest. Those are just two of the 11.
Can you point the court to anything that was contemporaneous with our founding, something that would be along the lines of the going armed laws or the surety laws?
So,
in other words, if we were to hold you to a historical analog that was contemporaneous, can you still prevail?
Yes, the state believes we absolutely can. Again, I would direct this court to James that collected 3 cases from the early 1800s. And I want to address this question. I appreciate the court's inquiry to this end, because in that case, they discuss a Massachusetts, Maine, and Rhode Island militia laws, all from the early 1800s, that prohibited those, including those with alcohol addictions, from militia service. And they found that those are analogous and allow for the prohibition on the right to keep or bear arms. And those are important here because those were broader restrictions on the right to keep or bear arms than what is.
Were they really, or were they instead a restriction on militia membership?
They are broader. While it does discuss militia.
Well, it doesn't disarm individuals who are not members of a militia, does it? I mean, correct me if I'm wrong, but that's my recollection.
In James, they explain that that prohibition was sound as an analog for prohibiting those with substance use disorders simply from possessing firearms. And so, again, this is a proper way to look at it, because again, this statute is nowhere near as restrictive as those.
And yeah, that was part of my inquiry, and is kind of piggybacking on Justice Stiegel's questions, is what was a historical analog at the time of the nation's founding was regulating behavior that the government or people that were thought to be dangerous.
Right.
And it doesn't go as far as saying intoxicated people are dangerous, but there are cases that talk about, and scenarios that talk about, the mentally ill, violent people.
Sure.
Would intoxicating, that was kind of my earlier question. How general can we be? You said that have to be the twin. I read that language. How close does it have to be when we're looking at the historical analog in your mind?
Again, it does not have to be a twin. It has to be close. And to directly answer your Honor's question, contrary to the defendant's claim at this point in time, the state actually does believe that the mentally ill, that category of offenders that have been historically prohibited from bearing arms, we believe that is an actually functional equivalent here. This isn't, again, that we're talking about someone that is presently under the influence of alcohol to a degree that they could not safely operate a firearm. We're talking about a moment in time, very brief. And so as a result, we do believe that is comparable to someone that is mentally ill. The case at issue, I believe it's cited by defendant Harrison in their brief. I would encourage this court to take a look at that case. I would ask this court to take a look because it's been reversed and remanded. So there is absolutely no support for the defendant's arguments in this case.
What about, there are some other potential analogs, 1655 Virginia prohibition of shooting any guns at drinkering, and a 1771 New York law banning firing of guns on certain holidays or correlated with consumption of intoxicating substances. But one might suggest that there's a distinction between firing and possession, and question, that's the how, I guess, and why questions that we ask, and the why, whether those were to preserve gunpowder or to prevent false alarm of attack, as opposed to protecting public safety. How should we reconcile those lines of analogs?
The state would suggest again that we do not need a historical twin here. And I think that this court can look at those prior statutes, ordinances, and consider whether we're talking about just use or for what that use is for, what that use is intended to prohibit, whether, again, as you know, preservation of gunpowder or public safety. Because what we're talking about, there is an analogy to be drawn that in those cases, they're talking about someone that has a gun in public and then arguably uses it. But there are, again, why can inform the analysis here, because what we're talking about is people in public that can't use a gun safely, even if they tried. And again, this statute, well, I haven't, not again, but this statute protects the right to use a gun to defend oneself still. So I think that that can lend some support, not as much as the, roughly 11 additional cases that the state has cited.
Thank you, Mr. Any other questions, call? Thank you, Mr. Gillette.
Thank you, Your Honors.
Mr. Reynolds.
Thank you. Good morning. Kelly Reynolds for the appellee Hunter Clift. Thank you for your time and may it please the court. Justice Rosen, I think you got right to the issue at the beginning of the state's oral argument here, asking what do we do with that? And you were inquiring.
You that's what you talk about in your brief. You really didn't address the district court's analysis. You kind of jumped into, not directly, but right for the wrong reason, and let's do the proper analysis. Is that kind of your position here this morning?
Yes, sir. The state's brief in its beginnings, the majority of it, I guess, was tearing apart the district court's analysis. And that's correct, Justice Rosen, it's not the correct analysis to be done here. I believe you have unlimited review of this issue as it's a constitutional issue. And I do believe that there's Kansas authority, as cited in my brief, that if we arrive at the correct result, it doesn't matter if the district court was erroneous, because you get to do this review and analysis independently.
So just our situation, I've sort of accurately positioned here. Our situation is that nobody likes what the district court did.
I will not say that,
Well, I mean,
Justice.
you like the outcome, you just don't like the way the district court connected the dots. Here's my problem. That approach that the district court used seems to tell me that you have a right to defend yourself with a firearm if you're drunk, if you're a domestic abuser, or if you're have a violent criminal history, that regardless of anything else, you've still got a right to defend yourself with your firearm. And don't we have to deal with that analysis first, if nothing else, to put it out of its misery, so that we can then get to the merits?
We do, Your Honor. And I believe that Heller and Bruin coming after it do address that there will be regulations of firearm use. There will be regulations of firearm possession. And a lot of these contemplate findings by courts. Findings by courts finding someone mentally ill, finding someone with a domestic violence tag, finding someone as a felon, which is a far cry from the type of statute we have here. But yes, there are times where there will be restrictions that are constitutional. So we see that. However, going back to the district court's analysis, we believe that they got to the correct result, but we believe the test is clear. The facial analysis, parsing of these tests, different tests, making them line up, Brunn is the correct analysis under Second Amendment jurisdiction, and under case law. And the Brunn analysis is simple. Well, none of them are simple, but it's very clear. It's a two-step analysis. I believe Justice Wall, perhaps you pointed out that the first step's met here, right? Justice Biles, thank you. The first step is met here. He's covered by the constitutional amendment, and therefore we get to the historical tradition, notably not historical example. Because a statute is old does not mean it's a historical tradition of firearm regulation in the way that we're contemplating here. Now, we do see numerous examples that have been pointed out. This one was from Justice Wall, I believe, about use versus possession, being able, the New Year's Eve revelers going abroad and firing their guns in celebration, specifically stated in numerous cases. That distinction is important here because Americans do have the right to armed self-defense. Now, again, there are reasonable exceptions to that, but this is not one of them. We have a statute here adding language that while in a vehicle, and it's perplexing why that specific portion of the statute is added in here. It does draw it more narrow. However,
well, don't you think that's pretty clear? This statute was enacted in 2012, and I think if you just go to a basic history, this was all about firing firearms from moving vehicles, and there was the legislature was attempting to address circumstances when that occurs. So why is that? And it really does narrow the scope of, I mean, this is a pretty narrowly written statute. It talks about loaded firearms, immediate control in a vehicle, and being intoxicated to such a degree that you're incapable of safely operating a firearm. Those are pretty limiting circumstances, wouldn't you agree?
I would agree. Additionally, the statute carves out exceptions, including the mere transitory possession is an exception to the statute. It's drawn so specific, I don't see how it's rendered moot from its very language. But people should not have to pay for a defense to go and assert that the statute will always have a defense. Additionally, on its face, without getting to the facts, on its face under Bruin, this is not allowed.
Let me just ask, where are you finding the transitory language? C1, the exceptions are C1 and C2. Are you saying C2 is transitory?
It says the mere transitory use of a weapon, as long as it's carried out for no longer than is necessary. The specific citation, yes, C2. During an act committed in self-defense, and I say.
Right, so that's not really transitory. That again has to do with self-defense, right?
Yes, Justice,
Okay.
and the transitory possession of a firearm is necessary. It's always for, it's arguable that it's always for self-defense. You cannot carry out self-defense unless you are possessing a firearm, at least armed self-defense. As far as the language of this statute goes, I believe that language makes it where this would never hold up on anything. Or there are numerous defenses that could attack this easily and early. However, under Bruin, we still believe it fails. Now, the state and Mr. Gillette stated that our client was more than twice the legal limit to operate a motor vehicle when this all occurred. However, he still had the good sense to immediately identify that there was a firearm there, that he had conceal and carry. So he had judgment enough to do that and judgment enough not to drive.
So did you raise in your motion to dismiss dismissal based on as applied? Because what you're talking about right now doesn't have to do with the facial challenge. It has to do with as applied to your clients.
Yes,
So do you believe that there was insufficient evidence that he was intoxicated to the point where he couldn't safely handle a gun?
I do. However, I don't believe we get there.
But was it raised in your motion to dismiss?
As applied was raised in our motion.
Okay, and did the district court rule on that?
They, as Mr. Gillette points out, the district court judge went through an overbreadth doctrine and a facial. I don't recall specifically, well, he talked about the facts a lot, but the specific fact of him having a concealed carry, things of that nature, I don't believe were part of his holding or part of his
Did you
rationale.
challenge that? Did you ask for more specific findings to address your argument in your motion to dismiss?
I did not.
Thanks.
And could we just, in terms of the factual findings that partly you're relying on here in the record, there was no hearing held on this, was there, in terms of what's the state's position and what's your position? What are the facts? I mean, it's even disputed that there were more than one of the identified vehicles, the black Dodge Challenger. District court says there's two of them. The state says, no, that's wrong. There's facts that are vehemently contested here, and there was no hearing. So what do we do with that? And justice standards in a facial challenge, I guess that doesn't matter. But if we're going to get into the factual scenario, what do we do, or how do we handle that?
Thank you, Justice Rosen. And respectfully, I don't believe we get there. Now, we raised it, as pointed out by Justice Standridge, we raised it in our motion to dismiss. However, I don't believe we get there. We did not want to cede any point. We wanted to raise every point that we thought was valid. However, I think case law from the High Court of the Nation is clear. The only test is the two-step Bruin analysis. So we do not get to the facts. Now, I do not want to concede anything on my client's behalf because I do think he would have had valid defenses if we were to get there. But the argument central to today is under the Bruin two-step analysis, and I don't think we get to any factual analysis, Judge. But it is correct that there was no factual hearing or evidentiary hearing that took place. The judge ruled on the briefs that were submitted.
Thank you.
We also hear from the state regarding the mentally ill. Again, this contemplates findings by a court that could prohibit someone from carrying a firearm. Again, it's
Can I ask you, before you start talking about the analogs, there is a question of what is our relevant time period for assessing these analogs? And, you know, there's sort of this open question, I think, after Heller, Bruin, and Rahimi, whether that's 1791 versus 1868, when the 14th Amendment was ratified. And I think if you look at a lot of originalist scholarship, there's, you know, a pretty strong argument, at least in the literature, that 1868 is particularly the relevant focus when we're talking about Second Amendment challenges to state law provisions. Would you agree with that? Or if not, why is when we're looking for historical analogs, are we looking at, you know, Reconstruction, that sort of era versus founding?
Thank you, Your Honor. I would not agree with that. I think all time periods are open for you to review and look at because we're talking about a historical tradition, not historical examples from 200 years ago, 150 years ago. And I think what would be exemplifying of a historical tradition is seeing more statutes start to take shape across the nation that are congruent with the tradition, not examples piecemealed from across states that most of which aren't even existent anymore.
But would you agree that the case for tradition, at least at a surface level, looks stronger if you look at 1868 and a little bit forward rather than starting at founding?
I could see that. I think looking back to contemporary statutes, not the founding, but yes, at the time of the enactment of the Second Amendment, yes. But I think it would take some time for this to disseminate through the nation, and therefore emphasis on the word tradition and multiple statutes being enacted, this being on the minds of state legislatures across the nation. We have piecemealed examples. That does not create a tradition, especially when the majority of the examples do deal with firearm use while intoxicated or others being impaired in some other fashion that contemplate a court finding of such. So yes, Justice Wall, to your point, I think all time periods are important. And that's for a very specific reason, because we don't see these multiplying. We see them challenged. We don't see a lot of examples recently. And we have a lot more case law to go on. In Bruin, I believe 2022. And some of these cases are making their way up. But the tradition should be well established. As Mr. Gillette said, it does not have to be a mirror copy. It doesn't have to be a twin. But I believe the key language that can be glossed over is tradition, and therefore multiple statutes piggybacking off of each other or gaining knowledge from each other.
Based on your argument, would you also, what would happen to a statute that says that, probably our I don't know if we have a statute that says this, but for someone who has a mental illness?
Well, I believe we do have statutes that contemplate that. I know in care and treatment cases, I believe there's prohibitions against having a firearm if there's a finding that one is a danger to themselves or others. However, the key difference is this involves court intervention and a finding and due process. I mean, I don't believe there are field sobriety tests for operating a firearm.
It goes to sufficiency of the evidence and an as-applied claim. We're talking about a facial challenge to a statute. Because under your argument, I guess, wouldn't you also have to be arguing that that's unconstitutional also?
Well, Justice Sanders, what I believe would be the response to that for a specific example would be substance use disorders. You know, there being a specific finding about that. So we're involving findings here, and my comment on the as applied, as you phrased it, is just that there's already a finding in place whenever these people are encountered. You know, violent offenders or felons, mentally ill, substance use disorder. So yes, I think.
But you're comparing substance use disorder to or I guess you're distinguishing substance use disorder from being drunk?
Well, in the sense that there's a finding for it and there's a diagnosable condition in the Diagnostic and Statistic Manual for Mental Disorders for substance use disorder, there are multiple layers of this being an actual finding or something more reliable upon and not generalized to the general public who do have the right to armed self-defense.
Right, but that's all going to as applied. I don't understand your facial argument, because we're looking at a historical analog. And would you or would you not agree that there is a historical analog for mentally ill people?
I would agree.
Right. And so I think your colleague mentioned that that's pretty similar, as far as mind altering to being intoxicated.
Yes, but I believe those involve a court finding of someone being mentally ill. So that's how it's distinguished in our eyes.
What? No, I was just, no, just
No,
go ahead.
My question's fairly quick, but it's back to some of the prior discussion about where we look in history. And I just want to ask you about the language in Bruin and Rahimi, both of which say that the test is to, and I think I'm quoting here, apply faithfully the balance struck by the founding generation to modern circumstances. Doesn't that tell us we have to look to the founding generation?
I believe you can and should look to the founding generation, but I believe the language contemplated by the Supreme Court in Bruin is what I was discussing earlier as far as it becoming a historical tradition of firearm regulation. Yes, you can and should absolutely look to statutes from hundreds of years ago, but the mere presence of a statute existing then is not a historical tradition.
Okay.
Does it have to be a statute existing or a tradition?
It does not have to be a statute.
Like going armed is, and surety, those are not.
Right. So the common law can provide clarity, and I believe that's fair. And I believe it's fair to observe what the common law was trying to achieve there, and it's the use of a weapon, going armed or a fray. And that's what was being contemplated with those, which distinguishes it from being a tradition in the sense that mere possession of the firearm is what's being prohibited, which is the case here, which is unconstitutional.
And I just say, oh, did you have a question, Sharon? So what do we do with, the Fifth and Fourth Circuit cases, which those circuits at least appear to me to have been more protective of the Second Amendment right than the Ninth or the Second Circuit? And both in Conley and in Daniels, they've rejected facial challenges to federal statutes, concluding that our history can support gun regulations disarming the presently intoxicated.
Well,
do we have to? I mean, we have to for your position to prevail. We have to disagree with that conclusion. But why? Why is my question to you? Why were they wrong?
well, I can't remember the year in which Connolly was decided. However, we would concede that that language is not helpful to our position. However, it's more generalized and not as specific in dealing with a statute that's talking about mere possession in various situations, being in a vehicle. Now, there is a carve out for being at home here, but they are distinguishable in that sense that the exact statutory language is different. And what we are stating is that it's unconstitutional for it to be possession in a vehicle or on your person, just in general for the general public.
It appears both of you appearing here today have identified a test that you think ought to be applied, the Bruin analysis, Rahimi, that approach. Is that something we should do? I mean, we can, it's a legal question, it's a facial challenge. We could do that. Or is that something that should be sent back for argument and let the district court do it in the way that you both agree should be done?
I think you do the analysis under Bruin, and I think that takes care of the entire issue.
We do it, not the district court.
Correct. Thank you, Justice Rosen.
The entire issue, as I understand, when raised in the district court, included a state constitutional claim, correct?
Correct.
Do you believe that is still a live claim?
I do. We won't concede in any of our initial challenges, and I would note that the Kansas Constitution Bill of Rights in Section 4.
Yeah, we don't have to talk about that, but just procedurally to clarify, the only thing in front of us is the Second Amendment. But if we rule against you, it requires a remand to consider the other issues the district court didn't reach. Is that
Correct.
your position?
Yes, Justice Stiegel.
Thank you. Colleagues, any other questions? Okay, thank you, Mr. Reynolds.
Thank you for the court's time.
Mr. Willett, you reserve 4 minutes.
Thank you, Your Honors. I want to begin by immediately pushing back on Justice Stiegel, your question about whether or not we have to look at only the founding. The language from the United States Court in Rahimi is quite clear. The reach of the Second Amendment is not limited only to those arms that were in existence at the founding. Rather, it extends prima facie to all instruments. Goes on to say that by the same logic, the Second Amendment permits more than just those regulations identical to those found in 1791. And I would add on top of that, the recent federal case law that notes the 14th Amendment as being a particularly relevant time, 1868, and that regulations around that time are important. And that's important for a particular reason, because until that time in 1868, not all people in this country were people.
Right, I understand the argument. And I understand that your earlier quotation goes to the fact that there does not have to be a historical twin.
Correct.
But could you address the language I quoted earlier about, I mean, this is the court in both Bruin and Rahimi, I think Rahimi was quoting Bruin, explaining what this test is. And they say explicitly, this is about balance. This is about respecting the balance that the founding generation struck and applying it to modern circumstances.
And that's why that is my answer is that's why the 14th Amendment is important, because to balance with modern circumstances at the very first level requires all courts to consider what a person is under the Second Amendment, to whom the Second Amendment applies. And so until 1868, the Second Amendment didn't apply to all people in the United States. It's only then that a person to whom the Second Amendment could be applied was established clearly in our Constitution. And that's what the federal cases that the state has cited point out as well. So we have to look at both.
Go ahead, Justice Wong. That's fine.
Well, just to continue on that point, I don't know if you've seen it, but Rahimi, the first footnote in that decision seems to, they acknowledge that there's this ongoing debate in the literature between what's more important, the founding or 1868. They acknowledge that that is an ongoing question, but said that we're not going to address it because we don't have to in this case.
Right.
So is that still just an open question?
I think that there may be a little bit of room for fighting about that. And I would note that in Connolly, where that question was answered, the United States Supreme Court didn't touch it. They declined review as far as the state is aware. Now the state, I will acknowledge that this is not, it's not in the record and it's not in either party's brief, but there are continued ongoing debates about possession versus, or those with disorders versus those that just are presently under the influence. I believe there was a case that was taken up on a review just in the last week. I don't know where that will ultimately go, but as to the ongoing debate about which time we look at, I think that the argument is compelling that it has to include 1868. And I guess I would also note that and at least, I think it was in Rahimi, there's at least an example that goes all the way back to England that talks about some of this stuff.
So we can go way back. What about the balance with modern circumstances?
Sure.
Modern circumstances, when our founding fathers were considering the Second Amendment and all the amendments, there weren't motor vehicles.
Correct.
There was no electricity. The firearms, I think, contemplated from then to now is different. I think we would all agree to that. How far can we go with the consideration of modern circumstances in balancing the historical tradition?
I think that this court can take into account all modern circumstances in trying to balance it with tradition. And as Your Honor noted, there are a number of things that come into play here. In addition to the extremely narrowly written statute here, we're talking about vehicles, we're talking about loaded weapons. The current times and the gun at issue in this case is a semi-automatic weapon that is far different than what existed at the time of our founding. So again, these are things because it changes the individual's ability to move about in public. It changes the level of risk to the public. Candidly, I think you could probably even consider alcohol. That has changed a whole lot since the time of our founding. And our ability to determine whether or not someone is under the influence.
I have one final question for me at least. And it often it doesn't matter, I suppose, but it might matter here. Do we apply a presumption of constitutionality to this statute?
I think the best way I have to answer that is to point to the correct test that's noted in Rahimi. It's not exactly a presumption that may exist in certain instances, because in this case, what is required as an initial step is for the state to demonstrate this historical tradition or similar analysis. And at that point, I think that the presumption can arise, because it is only at that point that the defendant is then required to demonstrate that there is no set of circumstances that exists. So yeah, I think to answer your question, yes, I think you can, number one, but number two, as this analysis proceeds, it's slightly different because this is a Second Amendment question, and that presumption could also arise through the application of the test here.
So, yeah, thank you, Justice Stegall. I wanted to clarify, do you agree you have the burden in a facial challenge under the Second Amendment?
We agree that we have an initial burden. We believe that burden was carried here. Had we had the opportunity to actually proceed to a hearing, we would have been able to further establish that burden was carried. Candidly, I think this court can look at the district court's ruling here, and whether the district court recognized it or not, it acknowledged the state carried that burden and then failed to hold the defendant to his. All right. If there are no further questions, the state would respectfully ask this court reverse and remand to the district court for further proceedings on the remainder of defendant's claims.
Any other questions, colleagues? Thank you, Mr. Gillette, and
Thank you.
thank you both for your arguments this morning. I'll call the next case on the 9 a.m. docket, State of Kansas versus John Boese. Case number 125691. Counsel, you may approach.
Good morning. May it please the court, the appellate petitioner, State of Kansas, appears by Stephen Obermeyer. I'm an assistant solicitor general. And The issue for the court this morning on petition for review was whether harmless error can ever apply to an alternative means error in a complaint
How
filed
is
in.
this is what's befuddled me about this.
Okay.
How is it an alternative means problem? Because always before, we had the defendant being charged with multiple means of committing the same crime. You didn't do that. The state didn't do that in this case. They charged this defendant with one means of committing the charge. That's a whole different problem, it seems to me. So to me, it's not even an alternative means issue, because that was trying to figure out whether, a jury was, and this doesn't even have a jury to it, but a jury convicted of one possibility versus another possibility when the jury was instructed on both of those possibilities. We don't have any of that here. So just because it's an alternative means problem, it seems to me what you're trying to do is say, well, we could have charged two different ways. We didn't, but now we want to go back and charge after we've had a trial. I don't even see how you characterize this as an alternative means problem. So start with that basic.
Sure.
Jumping off point.
The violation of a protective order statute there's 6 different ways a protective order can be violated. And the two at issue here is subsection A1, protection from abuse order, and subsection A6, a protection from stalking order. And the complaint charged the defendant with violating a court order filed in the District Court of Marion County, Kansas, where it states the defendant sent messages to his mother, whom the protected person, the victim, is residing with, the same being in violation of a protection order. The problem was the to-wit alleged was mistaken. It alleged he violated a protection from abuse order as opposed to a protection from stalking order. And I think that the case proceeded to try. The defendant was present when the protection order was issued, number one. The case proceeded to trial with nobody being confused about the fact that he was charged with violating a protection from stalking order. It was referenced in opening statements. The defense counsel cross-examined the victim about the protection from stalking order, argued the protection from stalking wasn't violated in closing arguments. And the district court recessed to deliberate and looked at the pattern instructions, which has the 6 different options, and said, I find the defendant guilty of violating a protection from stalking order. So to the effect we have a general verdict versus specific verdict issue that State versus Wright created, we don't have that. The judge said, I find you violated the protection from stalking statute. I think the issue is really the variance in the complaint. If you don't see the complaint as being broad enough to encompass that he violated the protection from stalking, the variance from the alleged protection from abuse order and the protection from stalking order. And there are cases, well, in State versus Reynolds, this court talked about.
In State versus Reynolds, the defendant was charged with both burglarizing a building and a dwelling. So those two things were charged. And when we got, toward the end of Reynolds, the state wanted to say, well, this is a charging document problem, and we analyzed it from there. But that's not the same thing as what's happening here. You're substituting a whole different set of facts that create a crime that weren't charged. The example I can't get out of my head with this one is the one that I always have with alternative means.
Okay.
Sodomy. Because you can commit sodomy, with a person or with an animal. And let's assume the state charged someone with sodomy with a person. Only everybody knew the case was about bestiality. And you're trying to say that at the end of the day, you can convict someone of sodomy, bestiality under the sodomy statute, even though you charged it with a person. That doesn't make any sense to me. And it's the same thing.
Okay.
I think.
I think I'm not sure what the complaint alleged in your example, but if it didn't allege the bestiality option.
Yeah, it doesn't, but
Okay.
your complaint doesn't allege the other option.
Okay.
That's
And-
why that's why I just don't even understand the premise.
Okay, I would direct the court to State versus Turbeville, which talks about issues where the complaint is essentially broadened beyond what is alleged in the complaint. And if the case proceeds to trial, and the evidence of the bestiality is admitted, and there's no objection to that instruction, then we have a variance issue where the complaint is essentially broadened. And the court in Fitzgerald says that those aren't issues that we've addressed. We've not argued instruction error, constructive amendment, or variance. And in your case, Justice Biles, I think the analysis would be, was it clearly erroneous to instruct the jury on the bestiality alternative means that when it wasn't charged? And I think you'd look to the harmless error statutes, the 60-2105 and 6261 and the 22-3414, and say, and consider whether the substantial rights of the defendant was violated when the complaint was, when there's a variance in the complaint and it was broadened to include that.
So following up on that, I guess the question I keep having is this even a substantial competent evidence or a sufficiency of the evidence case?
The Court of Appeals considered it as a sufficiency.
Right, but is it? I mean, there is no dispute at all, as far as I can tell, and it's not a jury trial, it's a trial to the bench.
Right.
About the evidence.
Right.
So what do we do with that?
The problem with the Court of Appeals, and this was first time on appeal, because in the district court, defense counsel and Mr. Boese didn't say, I don't know what I'm charged with. I need a bill of particulars. None of that. It's considered whether or not I think it's whether there's sufficient evidence of protection from stalking. The Court of Appeals said that. I think you frame the issue as, is there a variance in the complaint under Fitzgerald or constructive amendment to do that? And we don't have a jury trial, so we don't have the 22-3414 that might apply. But Reynolds also talks about the 6261 and the 60-2105.
So
harmless error.
As I understand your argument, it's that Mr. Boese was convicted of violating a protection from stalking order. That's the conviction.
And that's what the trial court specifically stated.
Which is why you say that's the conviction.
I'm sorry.
That's the reason that you're arguing that is the conviction.
Yes.
Because that's what the judge pronounced.
Correct.
You don't argue that was not in the charging document. In fact, the charging document charged a PFA violation. I'm just trying to lay the groundwork of that.
Yes.
Okay. And so I don't even think the defendant, we'll see, but I don't think the defendant would claim that if the conviction is for violating a PFS, there's no sufficiency problem here. Right?
Right.
That's your argument. So why are you, this was raised on appeal as a sufficiency claim. Why go into all the other stuff about variances and constructive amendments and so on?
As opposed to
why does that matter?
I was pointing out that what the Fitzgerald court did not consider the variance, and in this case that you had the abundant evidence of protection from stalking, whether or not that was an option in means or an alternative means.
Let me ask another background question. Was the only issue raised on appeal in this case sufficient evidence?
Under Fitzgerald, that the evidence was not sufficient to be violation of a protection from abuse statute. Yes.
So it seems to me the crucial question is, what was he convicted of? And if he was convicted of a PFS violation, the evidence was sufficient. And if it's a PFA violation, it wasn't sufficient. How is this case any more complicated than that? I guess that's what I'm really trying.
I don't think it is, except we had the state versus right and got into the alternative means, option within means, and there wasn't sufficient evidence of the protection from abuse option. And that's why the Court of Appeals said, unless and until until our Supreme Court clarifies Fitzgerald is no longer good law, we reaffirm our prior rulings. And I think in discussing the harmless error statutes in Fitzgerald and pointing out that in State versus Right, that language from State v. Right is dicta, that this should not be a structural error issue. It's whether or not the defendant was substantially prejudiced by the variance or the constructive amendment of the complaint when he did not object to admission of the protection from stalking order and knew what he was proceeding to trial. And this was not
I guess that goes back to my confusion about, frankly, the way the state has litigated this case. I mean, the state has brought in a whole lot of quote unquote error issues and talked about harmless error and structural error and so on. But the appeal the appeal didn't claim any errors, did it? The appeal just said there was not sufficient evidence. Am I wrong about that?
That's based upon State versus Fitzgerald.
Well, I'm reading the brief of appellant.
Okay.
And the way the issue is framed is, and it sort of goes to both of you, insufficient evidence supported Boese's conviction in that the state filed the wrong crime in its complaint, which is true. I mean, that's a given. But then it says, and Boese was found guilty of a different crime than what the evidence showed. And that gets to Justice Stiegel's point. And the evidence did show the crime that he was convicted of. So we've sort of got two different things at play here in the way that the defendant has issued. But it is a fact that he was convicted of a crime, of the wrong crime in the complaint. He was convicted of a crime that you did not charge. By definition, he did not commit the crime that you charged in the complaint because you were that specific.
I'm not sure that the crime is.
Whether it matters is a different question.
Okay.
But we can't dispute that this complaint involves a different crime than what he was convicted of. Of committing a crime in a way that he didn't do because he did it a different way.
Okay, it's because it's a different subsection. I don't think it's a different crime. I think the crime is violation of the protection order. You can do that 6 ways. It's not, you're charged with forgery and at trial, we find you guilty of making a false writing, like some Kafka-esque trial. He was charged with violation of protection.
That gets me back to my sodomy argument.
Okay, all right.
What do you have to tell the defendant when you want to throw them in jail that they did in order to throw them in jail? And if you charged sodomy with a person and the whole case is about bestiality, that's the problem that has to be unwound. That's all we're trying to do is identify what we've got to wrestle with here.
Okay. And when I get that complaint charging me with the wrong alternative means or wrong subsection, I'm going to get discovery in the case. I could file a bill of particulars. I'm going to have a preliminary hearing. I'm going to know what the evidence is against me. And so can I just sit back, not say anything and wait till the jury verdict and say, King's X, you charged me with the wrong crime. And I think that's what 22-30208 is against. If you find there's a defect in the complaint or if it's deficient, you need to raise that to the court. Otherwise, we'll assume you know what you were charged with and you're proceeding to trial. And certainly in this case, none of Mr. Boese wasn't shocked to find out that he violated the protection from stalking
Let
Can I go back
Please go ahead.
to pick up on the question about what is the crime of conviction, right? Because we've also got a judgment, a written journal entry of judgment that says the convictions for protection of abuse order. So is this a civil proceeding?
No.
Okay, what was your basis for appellate jurisdiction?
Well, the defendant appealed, direct appeal
Right.
from conviction.
Okay, so under the under the right to appeal from a criminal conviction.
Correct.
So even though the PFA proceedings are civil in nature, the violation puts it into the criminal arena. And so therefore your argument is that the pronouncement from the bench controls rather than the journal entry.
Right. And I argued in the initial brief that that's non-protunct material, that the journal entry doesn't accurately reflect what the transcript of the end of.
Well, it aligns with the charging document though, right? So, I mean, if it were to control, like if this were a civil proceeding, the journal entry would control, right? And then you would have a conviction that matched the conviction, and then sufficiency makes sense, right? Then you're testing the evidence against protection from abuse as opposed to stalking.
I can't speak to civil cases, Justice Wall, but if the judge said, I find you guilty of violating the protection from stalking statute, and the journal entry states protection from abuse, I think that's an error that should be corrected. The journal entry ought to be corrected. That's all I'm saying on that. If the judge mispronounces a sentence in court and the journal entry has something different, are we going to go with the bigger sentence in the journal entry because that's what it says? I don't think so. We go with what the judge said at the time of sentencing.
And under Fitzgerald, which was sodomy, and the difference was, let me pull this up. The difference was that the defendant was charged under 5504B2, which was causing a child under 14 to engage in sodomy with any person. But the jury was instructed under B1, which prohibited sodomy with a child who's under 14. The difference being, was it with the defendant or was it with any person? And in that case, we held, that there was insufficient evidence. How is this case different?
The interesting part in Fitzgerald is the jury was not instructed on sodomy with another person under that alternative.
Right.
They found him guilty of sodomy with the defendant. And I think the court kind of struggled with the state versus right analysis, but at the end of Fitzgerald, Justice Beyer writes, the state has not argued instruction error, constructive amendment, or variance, and supported any such argument with statutory law, common law, or constitutional authority. And I think this case, I don't think that it should be a structural error every time if you charge the wrong subsection under the same statute of the same crime, a different way of committing a protection from a.
So would we have to overrule Fitzgerald?
Well, the Court of Appeals wants that to be said, but I don't think you have to say we overrule Fitzgerald. I think you can look at the analysis in State versus Reynolds that.
Okay, let's assume that we don't find this as alternative means.
Okay.
Okay.
Then I think you're into the KSA 6261 and the 602105, the harmless error.
For insufficient evidence?
Well.
How can there be harmless error? I mean, Fitzgerald's pretty clear on that. How can insufficient evidence be subject to harmless error?
Well, there was sufficient evidence as to the stalking. I think, well,
But
okay.
the argument was there's insufficient evidence of the crime.
And the Fitzgerald court said, we are not considering variance. We're not considering the fact.
So we
that
would
the-
distinguish Fitzgerald by just saying, hey, they didn't raise this variance issue in Fitzgerald, but they raised it here, so we're all good.
I think so.
Is there any other way to distinguish Fitzgerald besides that?
Yes, we have the variance, we have the cases like State versus Turbeville where the charge in the jury and in the instruction or what the court found is broader than what's in the complaint. And Turbeville and cases like that say, if it doesn't violate the substantial rights of the defendant.
How is this broader?
It's broader because he's charged with, he was found guilty of a different subsection of the protection from stalking as opposed to the protection from abuse subsection, which I argued is an option within means. What does it matter to the defendant what kind of order he violates? The statute says you shouldn't violate a court order by contacting the victim.
What does it matter? I mean, that's the order you're charged with violating. I mean, is it due process issue? You know, you need to know what order you're charged with violating.
And I think Reynolds touches on it, and Griffin and State versus Grissom say it's not a due process violation. It's whether or not the substantial rights of the defendant are violated under the Kansas statutes. And clearly his substantial rights were not violated. He knew what he was charged with.
Any other questions of Mr. Obermeyer? You're out of time. Would you like to quickly summarize? And you did reserve 3 minutes.
I'll just come back.
Thank you, Mr. Okay, thank you. Mr. Whalen.
May it please the court, Michael Whalen on behalf of the appellant John Boese. Lest there remain any doubt about the constitutional stature of the reasonable doubt standard, we explicitly hold that the due process clause protects the accused against conviction, except upon proof beyond a reasonable doubt of every fact necessary to constitute the crime with which he is charged. In re Winship, United States Supreme Court, 1970. This principle has continued through Kansas legal history. If we look at Haberlein, McClelland, Chapman, all of them say that the charged crime is the crime for which the proof must be set.
What is the charged crime here?
It was subsection A1, violation of a protection from abuse
Well, there are two ways to look at it, right? I mean, subsection A just says violation of a protective order is : and then there's a bunch of subsections.
Yes, Your Honor.
So is the crime defined by sub A, violation of a protective order, with alternative means, or is each of those subsections a separate crime?
Each of those subsections is a separate crime.
So your argument is this is not an alternative means statute at all?
Not at all, no, Your Honor. Each one of these potential crimes under the 6 possibilities has a specific actus reus and mens rea. It is about what type of protection order they have intended to violate and knowingly making that action.
Are there different penalties associated with the different subsections?
I don't believe so, Your Honor, but I can't say for sure. I just don't know.
Why aren't they just different facts, each of which independently can support the elements of violating a protective order?
Because if we even look at it and take it from statutorily, how it is written, each one is separated by an and. Each one has different elements which need to be proved.
Yeah, different.
Not just an alternative means. It's not a different way of it. I guess it is a different way of committing the crime.
Isn't that
But
what we
each-
say alternative means is a different
But we're
way?
talking about a charging document, not an
Right,
alternative means issue.
I just wanted to understand
Okay.
your perspective on the statute first, and
Yes, Your
before
Honor.
we even get to the documents and so on.
Thank you, Justice.
What prejudice do you claim? I mean, everybody tried the case, knowing
Right.
what they were talking about. It's just the state cited the wrong subsection in charging it. So, I mean, that could create a prejudice. I understand. I'm just saying, do you have any here? There's some defense that didn't get raised, that would have been raised. There was different fact investigation that would have occurred. Something different, other than the fact that everybody knew what they were talking about. It's just the state put the wrong subsection in the charge.
The state has one job. That's to get the charge correct. In this case, and quite honestly, we have no evidence that perhaps this prosecutor wanted to charge this crime, and it wasn't just some mistake. The state has complete authority over the charges of crimes. The power of the state to charge and prosecute its citizens for criminal violations of the law is a fearsome one, and it is vested exclusively in a prosecutor who is given vast discretion to make both charging decisions and the myriad of practical and strategic decisions that occur in the course of a prosecution.
I understand
Yes, Your Honor.
that they had the obligation to do it right. Now, what we have to figure out is what's the consequence of that. One of the things that enters into the consequence is whether the defendant was hurt in some way in terms of how they would have defended the case, what would have happened. Did they not understand? They showed up for this bench trial wanting to defend against one kind of order, and son of a gun, they're talking about a different order, and the defendant didn't have any witnesses. Something that shows prejudice besides the fact it's their job and they didn't do it.
In those practical terms, I have to agree with you. There was not a set prejudice that came out of this. But this court has held consistently from Fitzgerald and cases beyond. And in State versus Lacey, the Court of Appeals gave a warning to prosecutors when they found insufficient evidence based on an incorrect crime being charged. And they said, this is an awesome responsibility. And when both the judge and the prosecutor miss it, it's a violation. And we are talking here about, I mean, this is a Sixth Amendment issue and the right to notice. And this goes all the way back to English common law, that the prosecutor is charged to present a complaint that shows the charge and what they believe the individual can be convicted of.
Mr. Whalen, as you know, Justice Biles asking about prejudice, and it all comes down to prejudice. But aren't you basically just saying that prejudice is not important in this case because insufficient evidence is not subject to a harmless error analysis?
It's not that the charge isn't subject to harmless error. It can't be harmless error because we are talking about a constitutional situation here.
Right, but you're claiming insufficient evidence, right?
Right. The state did not prove the charge that they filed.
Right, and so has there been a case where we have subjected insufficient evidence to a harmless error review?
No, not that I'm aware of, Your Honor. And
So
this kind of acts.
Can I follow up on that?
Yes,
I mean, it's certainly true that the charge as filed, I guess, if we want to consider it the specific subsection, which we should, was not proved. There's insufficient evidence. But that's not the crime he was convicted of. And I'm circling back to some of my earlier questions. So it strikes me that your argument starts out as insufficient evidence and then morphs into a lot of different kinds of errors, whether they're constitutional errors, due process errors, charging document errors under our case law. Am I correct that the reason for framing this as insufficiency is that the state doesn't get a second bite at the apple here? Because if this was raised as just an error, charging document error, or due process or what have you, I mean, this would be remanded for a new trial, right? Even if there was prejudice, if it wasn't harmless, it would be remanded for a new trial.
Well, it can't be because he's already been tried for his supposed crime.
I'm just asking.
Okay, I'm sorry.
Are you asking us to, are you framing this and asking us to find insufficient evidence
Yes,
effectively because your client can't be retried, essentially, because of double jeopardy issues?
I mean, that's not exactly why we're asking for it. We're
Well, it's
asking
a more
for it because I
benefit-
believe that's the precedent of this court.
It's a more beneficial outcome, but it goes to a doctrinal question, which is, I think, important here, which is the reason an individual cannot be retried when insufficient evidence is found is because that triggers double jeopardy protection.
Right.
And in this unique fact scenario, does it make sense to apply double jeopardy principles when what really happened, what we all know really happened, is just a mistake in the charging doc?
Well, I think it's analogous to the exclusionary rule where officers do something wrong.
Well, it might be
And-
analogous, but that's not part of our doctrine. I mean, we don't have an exclusionary rule on appellate remand. Do you see
I
that?
think State versus Lacey kind of does say that it's the prosecutor. This is such an important part of due process of our judicial system that it is important enough that the state act properly and do their job.
Right, which is why we always make them do it over. We say, you screwed up, do it over. And the only time we don't say do it over is when double jeopardy has attached. I guess I'm asking you to make your best argument for why double jeopardy attaches to your client here in this situation.
Because all the evidence of the underlying charge has been of what actually happened by the facts at trial have already been put out there. A determination has already been made. And
Well, that's not true. If you look at the charge, there's no, the state didn't put on an evidence. That's your whole point. The state didn't put on evidence.
Right.
Of the charge.
Of that charge. Right. But all the evidence that would come from a filing, a refiling under the subsection has already been put before the court, has already been found, as I believe noted by Justice Biles, that he was found to have been convicted of violating a protection from stalking ordinance. And also, it would prevent, I think it would impact his ability to work out another plea argument where it again recharged.
Okay. I appreciate you engaging in my prolonged back and forth. I'm sorry I took up so much of your time.
It's always a pleasure, Justice. Thank you.
Can I back you up to the statute itself again? In subsection A, you suggested that the elements, subsections A1 through 6 differ. Do they differ only in the type of protective order that's being violated? Or is there more nuance to it than that?
I think the only nuance with that is, yes, they are each separate types of orders and how they can be violated. And it requires a different mindset or intent by the defendant to violate each one of those separate orders.
How so?
Well, if you have a protection from abuse, it's contact with the individual and knowingly violating a protection from abuse order. The other is completely different underlying criminal action, that of stalking. And it's to knowingly violate the order that has been imposed against you.
Contact's not necessary under stalking.
I'm sorry, Your Honor?
Contact's not necessary under stalking.
That's correct, Your Honor.
Be out on the street corner.
Yes, Your Honor.
Okay. So that's one answer to the question. There's a different way of violating different orders.
Thank you, Your Honor. If there are no other questions, I'll step back. Thank you all.
Any other questions? Wait a second. Oh, no. Okay. Thank you for your argument, Mr. Webb. Mr. Obermeyer, you're reserved 3 minutes.
Thank you. Following up on Justice Wall's questions, I think there's 6 different orders that can be violated. I read that as what would be an option within means under the State versus Brown line of cases. You don't have to have different actus reus for the different kinds of violations. And if it is an option within means, then it doesn't matter that the complaint alleged a violation from a protection order versus violation from a stalking order. And clearly, there was no prejudice, and the appellate court shall disregard all mere technical errors and irregularities that do not affirmatively appear to have prejudicially affected the substantial rights of the party complaining. As to, I did omit to mention, I had filed a 609 letter where this wrong subsection was filed in a Pennsylvania case. And the court says that that's not a due process issue. That's not a violation. And it depends on how the court frames it. If you frame it as a sufficiency of evidence case, that's one thing. If you frame it as a sufficiency of the complaint, it's a different argument.
Let me ask you a question. Let's say hypothetically that instead of the difference between A1 and A6, it was A1 and A5. 5 being violation of an order on post-release conditions. Would your argument be the same, that they're just options within means?
I think it would be the same. And I covered that in my initial brief of appellee. But so there's evidence at trial that it's a post-release order that's being violated and it's charged as protection from
Abuse.
I think it would be the same. I think I would have the same argument as long as the defendant is on notice as far as what he was charged with and what the evidence against him was, and can't show that this was a trial by ambush, that this isn't what I thought I was going to trial on.
Well, is that a factual determination, whether the defendant was on notice? Because that's pretty different. Violating, especially if the person does actually, I mean, because what you're saying, this isn't just going to apply to this case. This is going to apply to all of our cases going forward that, hey, this is not sufficiency of the evidence because, all the evidence supported, the crime that we intended. But if in the hypothetical I gave you that this person really did have what was on post-release supervision at the time, that he violated a PFA?
I think it would be the same analysis whether or not he was prejudiced by that constructive amendment or that variance from what the complaint alleged and what the evidence presented at the trial was.
Right, but so then you're saying that going forward, insufficient evidence would be subjected to harmless error analysis.
I don't think that would be the holding. I think it would be if there's a different subsection and there's evidence and the complaint is essentially broad to include another alternative means or option within means, that would be subject to harmless error. And I direct the court to take a look at State versus Turbeville. And there's a line of cases on that where charged with one subsection, convicted under another subsection of the same statute. It's the same crime. This isn't a forgery, false writing.
What year was that? Was that before or after Fitzgerald?
It was in the 70s or 80s.
Okay. And then one other question. Bottom line here, just bottom line.
Sure.
We're going through a lot of, as we say, legal gymnastics.
Right.
When the bottom line here is the state just made a mistake. Why should we try to fit a square peg in a round hole to do all these mental gymnastics when the bottom line is the state made a mistake? Let's just hold them to it.
Well, I would, if you look at the statistics on how many cases are filed a year, criminal cases across the state of Kansas, it's a big number, I'm sure. You're going to have some errors on that.
And so
and-
the Supreme Court should, try to fix those errors, even if it messes up our precedent. I mean, it's just.
Well, but we have the statute saying if the complaint's deficient, the defendant should raise that. And we have the harmless error statutes. And sure, if the prosecutor, change, in the supplemental
But
brief.
then that put the burden on the defendant? Why should the defendant have to do that? The state is responsible for charging the crime.
And if it's deficient, then he should raise that. Otherwise, he's had discovery. This person was in
But then you're
court,
going to notice, and you're going to all this stuff that has to do with harmless error.
right?
Okay, I'm talking about you charged a crime, you did it wrong, there was insufficient evidence of the crime you charged, and now you're all the way up here at the Supreme Court saying, we made a mistake, and so can you do some legal gymnastics and figure out how to fix it?
I'm saying that that harmless error should apply on complaints that charge the wrong subsection of the case. If there's no prejudice in that situation.
Thank you.
And I direct you to look at that Pennsylvania case because it happens in other states also. But so for the reasons argued in this original and supplemental brief, there was no prejudice. He knew what he was charged with. He was found guilty of protection from stalking, so it's not a state versus right violation. And I'd ask that that the Court of Appeals be reversed. Thank you.
Thank you, Mr. Obermeyer. Thank you, counsel, for your arguments here this morning. Court will be in recess until 9 a.m. Thursday morning, tomorrow morning. Thank you.